When the licensing laws were created, there were some folks that said, hey, I don't need to be licensed. Why should I have to have a license? And typically, whenever a licensing law is passed, there are some reasonable exceptions where people don't have to have a real estate or other type of license in order to conduct activities in that profession. So let's take a look at the activities that are real estate related where the statutes exempt them from licensure. First is a for sale by owner. So someone buying, selling, leasing, or renting their own properties don't need to have a real estate license. Why? Well, remember, you have to have a real estate license if you work for somebody else and for compensation. So as long as you're doing it for yourself, you don't need a real estate license. I love the sign. It says, for sale by owner, must sell, lost job, can't pay mortgage, wife left, took dog, house a gem except for asbestos. Best offer. Well, most of the for sale by owners out there don't really tell all the truth all the time. This guy is really telling all the truth. So for sale by owners, people buying, selling, leasing, or renting their own property do not have to have a real estate license. Secondly, an attorney, lawyers, who's performing the duties that a lawyer typically performs. So, an attorney preparing contracts, giving legal advice, and so on relating to real estate, that's perfectly within the framework of what an attorney does. However, if an attorney was interested in marketing real estate and showing property and doing the things that a real estate broker does and receiving commissions in real estate, then that attorney would have to have a real estate license. I'll never forget, many years ago in a broker's class, we were talking about this, and one of the men in the class got up and he left shortly after our discussion. It was about 9 o'clock at night. And the next evening he came to class and he said, you know, I'm sorry, Jim, that I left class early last night, but I'm in a very large commercial real estate transaction. And the attorney on the other side of the transaction was trying to get a large portion of my commission. And when we talked about this last night, I had to get home and call him. I called him up, referred him to the statute that says that he would really not be entitled to any commission, and he backed off. He said, you saved me $20,000 last night. So, a lawyer does not need a real estate license, but if they want to participate in real estate compensation and perform activities that a broker performs, then that attorney must have a real estate license. The next one here is an attorney in fact, acting in an isolated transaction. Some of you may have acted as an attorney in fact for a friend or a relative where they could not be present in a real estate transaction. What they would have given you is what's called a power of attorney, authorizing you to sign their name and act on their behalf. By that power of attorney, you became their attorney in fact. Now, if you're acting in an isolated transaction, you can be compensated for that and not have a real estate license. However, if someone was trying to conduct a real estate business by using powers of attorney, that would be illegal. Then they would be circumventing this law. They would have to have a license. Another is a referee or a trustee in bankruptcy. So if in a bankruptcy real estate needs to be sold, the referee or trustee can sell that real estate without having a real estate license. How about a trustee foreclosing under a deed of trust? No, a real estate license is not required, although only certain persons or corporations can act as a trustee under a deed of trust. Also, government employees in the performance of their duties. So, for example, the sheriff conducting an eviction or conducting a foreclosure auction, he or she would not need to have a real estate license. Or oftentimes cities and counties have real estate divisions and they have employees who are not licensed to assist in buying and selling real estate on behalf of the city or the county. They would not need to be licensed either. Now this one's kind of interesting. The apartment manager or on-site leasing agent of an apartment complex, so long as they are only at one location per day. So let's take this on-site leasing agent who is not licensed, and he or she is leasing apartments in a 200-unit apartment complex. That person does not have to have a real estate license so long as he or she is not at more than one property per day. So for example, let's say a property management company or just an owner has 5 apartment complexes throughout the city. And they have a leasing agent who goes to apartment property A on Monday, property B on Tuesday, and so on. That person does not need to be licensed. But if they were at property A in the morning and property B in the afternoon, they would have to be licensed. So apartment managers or leasing agents who are at only one location per day do not have to have a real estate license. Another question comes up relative to their compensation. So let's presume these people are salaried. Can they receive bonuses? The answer is yes, they can. But they can't receive them more than monthly, and the maximum bonus they can receive is 1/2 their regular compensation. So let's say somebody was earning $2,000 a month as a leasing agent on their base salary, yet they were very successful in bringing new tenants into the property. They could actually receive an extra $1,000 a month as a bonus in that particular situation. The last exemption we want to mention here is employees of a real estate firm, such as administrative staff, receptionists, and so on, as well as telemarketers. Telemarketers who perform very limited services. They can't negotiate transactions. Maybe these telemarketers are trying to set up appointments for other real estate agents. That would not require a license either. One last point to make is that real estate auctioneers must be licensed by the Department of Real Estate. There are a long list of services that the statutes say require a real estate broker's license, and one of them is real estate auctioneering. So I don't know if you've ever been to a real estate auction, especially for foreclosed properties, but where the bank may have acquired 20, 30, 50 properties, sometimes they auction these off. And it's kind of an exciting atmosphere. Well, the person who's conducting the auction and the ring men or women who are out in the audience actually negotiating a sale on the floor of the auction, they also have to be licensed. And licensed by whom? By the Department of Real Estate. Let's take a minute or two and talk now about activating your license or paying your fees to the department. Whether it's a salesperson or broker's license, it can be on active versus inactive status. What I'd like to emphasize here is that a person must place their license either on inactive or active status within 1 year from passing the real estate exam. So once you pass your exam, mark your calendar, especially if you're not going to put your license active or inactive right away, because that year can go by pretty quickly. And if for some reason you fail to pay your fees and place it on inactive or active status within that year, you'd have to take the test over again. So mark your calendars from the day you pass your real estate exam. Of course, if you're going to activate your license with a broker right away, then it's a non-issue. Now, the original license is issued for a 2-year license period, and it's issued from the end of the month in which you activate your license. So let's say that you pass your examination on April 15th, an auspicious day here in the United States, tax day. So let's say it's April 15th, 2019. Your license will be issued from April 15th, 2019 through the end of April 2021. The renewal period for your license is 2 years. So every 2 years, starting in that example from the end of April 2021, your license will have to be renewed, and again through the end of April, in that circumstance, 2023. As a salesperson, in order to activate your license, aside from the basic 90-hour course, a salesperson has to take a contract writing class. And again, this must be completed in order to activate the license, not required to take the state examination. Brokers have to take broker management classes, actually 3 broker management classes, and again, in order to activate their license, but not in order to take the examination. To renew your license, first renewal for 2 years and subsequent renewals also every 2 years. If you don't renew your license on a timely basis, that license is deemed to be expired. Make a note for yourself. Expired, the term is not suspended or revoked. If you see the term suspended or revoked on your exam, that means that there was some disciplinary action. But just failure to renew your license is expired. And today there's really no reason to fail to renew your license on a timely basis, because you actually get an email from the Department of Real Estate 90 days out, 60 days out, 30 days out, reminding you to renew your license. Your broker also receives an email from the department at least 30 days out, reminding them that the salespeople that they have to renew their license as well. If you do business once your license is expired, you're acting illegally. In fact, if you do business once your license expired, when you go to renew your license, the real estate department will ask if you have conducted business during that time. And of course, if you have, the answer is yes, and you may be asked to disclose the transactions that you were involved with, and you may actually be asked to give those commissions back to the people who paid them to you. So keep in mind that if your license expired, you're not allowed to conduct business. One other point here. Just because your license expired doesn't mean that you are not entitled to receive compensation for transactions you put together when your license was active. For example, let's say that you had a transaction in escrow, your license expired, maybe you decided you no longer want to conduct real estate business, so you put the transaction in escrow a month before your license expired, but you did not renew your license. Let's say the transaction closes 3 weeks after your license expired. Are you entitled to that commission? The answer is yes, you are. Why? Because you were licensed when the claim on the commission arose. You were licensed when you put the transaction together. You have 1 year from the time your license has expired to renew it. That's called a 1-year grace period. So if your license expired today, you would have 1 year from today to pay your licensing fees, take your continuing education, and you would be back in the saddle again. If you wait more than that year, that 1 year grace period goes by, and you do not renew your license is terminated at that particular point. And then in order to be able to get your license again, you would have to go and take the examination and possibly the course. If you do renew your license on an untimely basis, in other words, after your license expired during the grace period, there is an additional late fee that you would be charged. It's not exorbitant. You don't have to know the exact number, but there is a late fee that will be charged. How about continuing education to renew your license? The answer is yes. Salespeople and associate brokers have to take at least 24 hours of continuing education every 2 years. There are mandatory and elective categories. In fact, there are 6 mandatory categories that make up 18 hours, 3 hours in each of those categories at a minimum. So there's at least 6 hours of elective that you can take. So that 24 hours is for salespersons and associate brokers. But designated brokers, self-employed brokers, and associate brokers who have this delegated authority to review and initial contracts, they have to take 30 hours of continuing education. The extra hours there deal with what are called these broker management clinics. And again, there are mandatory and elective categories for brokers. The last thing I want to talk about here is the temporary broker's license. And this is when the broker is gone for good. I'm sorry for my slightly dark humor here, but a temporary broker's license is typically issued or might be issued upon the death of a broker. Death or serious incapacity of the broker. So let's say a broker passes away, but there's business that's been transacted, transactions to be closed still, and maybe the spouse or next of kin needs to wind down that business or sell the company. In that circumstance, when that broker is incapacitated or deceased, that license can be issued. An actual license now from the real estate department can be applied for and issued for up to 90 days to the spouse, next of kin, or executor of the deceased broker's estate. So these people, by the way, do not have to have a salesperson's license. They don't have to take any education. But the idea here is that this license might be issued to be able to allow the family or the estate to wind down the business. So that's the temporary broker's license. Make a distinction between a temporary broker's license, a license issued by the real estate department, to the temporary absence of a broker, where the broker might be unable to act for more than 24 hours, as we talked about a little bit earlier. So that's our discussion on Article 2 of Title 32, Chapter 20 of the Arizona Revised Statutes. Article 2 deals with licensing. And in the next lesson, we're going to talk about Article 3, which is regulation of licensees.